I appreciate all of you attending. What we're going to discuss, obviously, is opening statements. I'm going to discuss a little bit about my career first and how I jumped off into the world of criminal law. He is correct. I did start as a prosecutor. And have you ever sat down to a dish or a meal of some kind and you said to yourself, man, I can't wait to dig into that. You thought it was going to taste wonderful. You were excited. You were geared up. And then all of a sudden you took a big bite and you're like, bleh. You know what? That's frankly what happened to me in my career as a prosecutor. Nothing against the prosecutor's office. They do great work. There's a lot of great people. There's some exceptional trial lawyers. But I'll be honest with you, I went to law school because I thought being a prosecutor was where it was at. It's what I wanted to do. I'd worked at the prosecutor's office in Tulsa County under Tim Harris, who was the elected DA there. Loved it, worked all 3 years for him, got a job at the Jackson County Prosecutor's Office, and I said to myself, this isn't what I thought it would be. It's just not what I thought it would be. I wasn't enthused to show up to work. I was surrounded by people who really, their drug of choice was power. That's not my drug of choice. It wasn't, I wasn't enthusiastic about it. I think prosecutors are great. I think there's a great need for them, have a lot of respect for them, but it wasn't for me. Have you ever been in a position where you sat down to that meal and you said to yourself, wow, it looks good, but then you take a bite and it's not for you? Raise your hand. You're in good company. Believe me, I was there. So what happened? I hung my shingle. I was scared to death. I had a newborn baby, had all the bills. Wife was scared. I was in the bathtub crying. And I'll tell you what, I was scared to death. I was in the bathtub crying like a baby. Young lawyers, if you have not been in the bathtub crying yet, believe me, you will. This profession will bring you to your knees. At some point, you will be in the bathtub crying. I still occasionally am there. But what I will say is that moment, there was a lot of fear, a lot of anxiety, but you know what I learned real quick about the defense bar that I didn't find in the prosecutor's office? What did I find, folks? There's some defense attorneys in here. What did I find? Open, communication, collegial, beautiful, beautiful. What else?
A sense of community?
Yeah, a sense of community. I didn't find it as a prosecutor. There might be prosecutors who find that, but I didn't find it. What else?
People willing to help you out.
People willing to help you out. Have you ever thought it was strange that in law school, nobody really wanted to help one another? There's this sense of, let me hide the outline. Let me, form my own little study group. And if you want to be a part of it, arm's length, buddy. That's what I didn't want to be a part of. I wanted to be a part of a community that was collegial, open, supportive. You know what I found as a defense attorney? I'm right at home, baby. I am right at home. So if you have not found that, I will tell you, keep searching, because that's the best part of being a lawyer, among other things, but that's one of the best parts about being a lawyer. So for those defense attorneys out there, thank you. Thank you, okay? Because when, and I almost tear up when I say this, when I jumped out on my own, you guys were there to catch me. You guys were there to share motions. I didn't even know, electronic filing had just kicked off. I was like, wait, how do I do this? Reached out to a defense attorney. Hey, buddy, here's what we do, okay? Walk you through this. I want to thank each and every one of you defense attorneys out there for being there and being supportive and giving me the help that I needed. I didn't deserve it, but I really, really needed it, and you guys were there. So, I want to tell you let's start with this. How many fresh attorneys, fresh out of law school, are there? There's 1, 2, 3, 4. So we got 5, 6. It's okay. Don't be embarrassed. It's a good thing. You're fresh out. It's an exciting adventure. So we got about 5. Let me tell you, there are some folks in here that would be happy to mentor you, present company included, would be thrilled to mentor you just to pay it down the line. So after this, I will tell you, you've got my website on there. If you're like, man, I could use a mentor, if I can't do it, I'll find somebody that can. I will, all right? So you make sure you reach out to me because there are some brilliant people in this room. If I cannot connect you with what you need, I will set you up with someone that really can, because this profession is so fun. And what an honor. You know, really, what an honor to be able to stand up in a court of law and represent another human being. Right? Let that sink in for a moment. I mean, think about that. You are standing up in a court of law and you are representing another human being. That is such a powerful thing. Sends chills down my spine every single time I get up in front of a judge and I have a client next to me and I say to myself, man, I am the luckiest dude in this world. I'm so fortunate. And I will always, always, always say that because this job is so much fun. So let's talk a little bit about opening statements. Let's get the decorum out of the way, all right? What keeps a lot of people from jumping into trial work, it's not the fact that they don't know the law. That's easy, okay? You can find the law on just about anything if you have the time, energy, money, whatever. You can pay somebody to research the law. It's not an absence of determination or courage. All of you have that. Oftentimes it's just procedure. You just don't know the procedure, the decorum. So somebody tell me, you've just picked a jury, the judge has just read the instructions, the judge is looking to you, right after the prosecutor obviously goes, but looking to you to begin your opening. In terms of just general procedure and decorum, what do you do? Yes, sir.
Introduce yourself.
Okay. Okay, even before that. Good, but even before that.
Stand up.
Stand up. Good. Okay. Yes.
Probably thank the jury for being there.
Okay, thank the jury for being there. Sure, but even before that.
Take a deep breath.
Okay, take a deep breath. Absolutely. Absolutely. It's amazing that the same response in terms of fight or flight is triggered with public speaking. Isn't that weird? That if I were being chased down by a saber-toothed tiger, the same type of response I would feel is the same that I'm feeling right now. That kind of burst of adrenaline, heart beating, that nervous, scared feeling. Absolutely. Very similar. What else? In terms of decorum, think about it. May it please the court, okay? May it please the court. So you're looking to the judge first. The judge says to you, counsel, you look to the judge. Before you ever kick off anything, you look to the judge, may it please the court, okay? Simple enough. You look to the other side. You look to the prosecutor's table. Counsel. Then who do you look to? The jury. So, may it please the court, counsel, ladies and gentlemen of the jury. Then you begin your opening. Then you begin your opening. Have a seat, ma'am. Come on in. Come on in. Join.
Looking for a place.
There's definitely a place for you. Okay, so let's walk through that again. May it please the court. You look at the judge, because remember, you've already selected the jury. The judge has read the instruction. The judge has provided time for the prosecutor to give their opening. You're next in terms of the defense. All right? You look at the judge. May it please the court. You look at the opposing counsel's table, counsel, and then ladies and gentlemen of the jury. And then you are off to the races. Okay? Any questions about that? There are so many occasions where I think people, they don't jump into trial work because it's those small things. It's not the opening that keeps them from doing it. It's just those small little procedural aspects. Okay, so I put this up on every CLE I do. A black belt is simply a white belt who never quit. And I won't tell you war stories, but I will tell you, when I was a prosecutor, I tried everything I could touch, everything. And I'll tell you what, I lost damn near everything, okay? I lost a lot. And I said to myself, I am the worst trial lawyer that Kansas City has ever seen. I lost a case where the defendant confessed. How do you do that? How in the hell do you lose a case as a prosecutor when the defendant says, I committed the crime? That is ridiculous, okay? But I will tell you, I lost that case and I lost so many others. A black belt is simply a white belt who never quit. In terms of defense, and I don't know what everybody does here, but in terms of defense, are you interested in defense? Well, a lot of you are, great. Yellow belt, are you comfortable walking your client through a guilty plea? Okay, great. Brown belt, are you comfortable taking a case to trial? Black belt, are you willing to donate your time and talents? Thank you, folks that work for legal aid. Thank you, public defenders. I know we have some of you in here. You are black belts, my friend. You are donating your time and talents to the folks that really need it. We appreciate you. Guess what? We do. And we know you work hard. And we know you don't get told thank you enough. Okay? We know that. But I will tell you, this is when you know you've really made it. When you're willing to donate your time and talents to folks that really need you. And man, this country is full of them. And if you're in the private world, guess what? You have an obligation to donate your time and talents to those folks too. Put them on a payment plan. Or, you know, if somebody's really destitute, take their case for free. It is not going to make a dent in your bottom line. In fact, if anything, what I found is it will raise it considerably. Because that person is going to tell thousands of people about you. They will. They'll tell thousands of people about you. And especially in the age of the internet, they're going to tell someone on the internet and it's just going to it's going to jump off big time. So you're not going to lose money. You're going to make money for all those folks out there in private. Okay. But where I was going with the aspect of losing, it's okay to lose. All right? You're going to lose a lot. And, you know, you're going to get to that point where you think, I'm not cut out for this profession because if I was a good fit, I'd be winning more. I'd be winning some. You know, I said that to myself. I went to a judge and I said, I'm done, dude. I said, I am done. And he goes, well, he says, you do have a lot of flaws in your trial work. But he says, you know, he told me something. He said, when he was a federal prosecutor, and this is Judge Powell said he lost enough cases where he was ready to throw in the towel. And he said, I was right there. I was the same way I told my wife, and his wife's a federal judge. And he had told his wife, Beth, I'm ready to throw in the towel. I'm done. I'm not cut out for this. And because he'd lost a string, and everybody goes through that. I mean, I can tell you, when I lost that case that with the confession, once again, I'm in my bathtub crying. And I'm like, this is terrible. I mean, I was not cut out for this. But I will tell you what's going to happen is when you think you can't take any more, you are going to hit some big wins. You are going to hit some really big wins. And I tell you, for me, what happened is when I jumped out on my own and started doing defense work, I'd realized all those losses as a prosecutor, that was getting me ready to win some big cases as a defense attorney that were going to help me get on my feet. Probably the biggest case financially that I won, I didn't make a whole lot off of it, but I represented a bondsman. And he was in some big trouble, and we won his case at jury. And that individual has never forgotten my name. Every single time he comes across somebody that he bonds out, he tells them my name. So it ended up working out. The case, you know, looking back, the case that I really needed to win in terms of my career was that one. I had thought as a prosecutor, all the ones leading up to that were the ones I needed to win. But it's funny what hindsight's able to do for you as far as perspective. So anyway, don't be afraid to lose. Do not be afraid to lose. I know it hurts. Believe me, I know it hurts. But it's going to get you ready for that big win that's coming down the pike. All right. So what's the purpose of an opening statement? Somebody tell me. What's the purpose? Among other things. What's the purpose? Yes, sir.
It's the preview of the evidence.
Great. Good. Thank you. Preview. What else?
Tell the defense story.
Okay. Great. Thank you. What else?
Humanize your client.
Absolutely. Humanize your client. Absolutely. And that's not just for gamesmanship. It's because your client is a real person. During your opening, put your hand on their shoulder. Okay? Use their full name. Don't refer to them as the defendant. What else?
Make a good first impression of the jury.
Absolutely. You built some rapport during voir dire. Absolutely. And then you're cashing in on some of that during your opening and throughout the trial. But you've definitely built some rapport during voir dire. It's just like when a lot of you walked in here. I mean, trust me, it's nerve-wracking, but I shook hands, smiled, and said hello, because I want to build rapport with you. I want you to know you're welcome here, so that now, as we're going through this, there's a little bit of a connection. Not much, but there's a little, hopefully. Same thing with the jury. What else? Yes?
Make it clear that the government is coming after your client.
Okay, sure. Good. What else? What else? Anything else you can think of? Yes? You, sir, in the polo shirt. Did you have your hand up? No. Okay. Anything else you can think of?
Lay out your defense.
Okay. Lay out your defense. Excellent. Yes?
A roadmap of what to look for that you're going to be bringing out.
Absolutely. So you're gonna have, and this is one of the things that I enjoy about being on the defense side, is you're gonna have an opportunity to respond, because the prosecutor's case in chief obviously goes first, okay? So the prosecutor's opening goes before your opening. So pay attention. I know that when you're sitting there and you're thinking to yourself, okay, I gotta think about my opening, think not so much about your opening, but listen to what the prosecutor is saying. Be able to respond in your opening to their opening. The other aspect is don't memorize. Why would you want to avoid memorizing? Okay. Sure. You don't want to sound like it's just a cookie cutter speech. What else?
Well, you want to make adjustments to their opening.
Beautiful. Absolutely. Did everybody hear what she said? She said you want to be able to make adjustments to their opening. What else? Why else do you want to avoid memorizing? Yes?
Well, you don't want to be impersonal and become like a robot. You want to be very personalized with the jury and everybody in the group, especially to humanize your client.
Absolutely. Spontaneity. The jury is going to pick up on that. The same reason why it's difficult to listen to a professor who has memorized their lecture. It's so hard to listen to if they've memorized it. But if there's spontaneity, then you're part of the lecture. You're part of the process. And the jury will feel as though they're part of the process as well. Okay, so let's go back to some general procedure. Let's go back. So what do you want to remember in terms of creating your opening and delivering it in terms of procedure? So we talked about the very front end. Okay, we talked about, may it please the court, counsel, ladies and gentlemen of the jury. Now you're stepping in front and center and you're opening your case. All right, now let's talk about procedure. What do you want to make sure that you do? What do you want to make sure you do? Yes, sir.
I want to tell the jury that what they just heard from the prosecutor is not evidence.
Okay, great. Elaborate. Beautiful.
And you also want to tell the jury that you ask them to keep an open mind until they've heard the entire case.
Great. So why do you say that an opening statement, and for that matter a closing statement, are not evidence? Tell me more.
Because it's not evidence.
Oh.
The evidence comes from the witnesses and from the exhibits.
Okay. Could everybody hear that? Please say that one more time.
I said because what the prosecutor says is not evidence. The evidence comes from the testimony of the witnesses and from the exhibits that are introduced.
Absolutely. Your opening is not evidence. All right? Your opening is a preview of the evidence. Does everybody understand how that is distinguished? It's not evidence, just like your closing is not evidence. Your closing is essentially a summary of the evidence and its argument concerning the evidence, but it's not evidence. Your opening is not evidence, it's a preview of the evidence. So, once again, the purpose of an opening statement is to inform the court and jury as to the nature of the case, give an outline of the anticipated proof, and point out the significance of the evidence as it will be presented. So, the easiest way to open your case, first thing, to say what? Easiest way. Ladies and gentlemen of the jury, the evidence will show. That's because I'm going to tell you right now, that's what the judge is expecting to hear from you. Ladies and gentlemen of the jury, the evidence will show. If you don't include that on the front end, you're going to get a big fat objection real quick. If you go into argument, if you start personalizing, if you start essentially using it as a closing statement, you're going to get a big fat objection. And then all of a sudden your momentum is going to go, all right? And you're going to feel like, oh no, how am I going to get through the rest of this trial? I've already bungled this up. You're not going to bungle it up if you say, ladies and gentlemen of the jury, the evidence will show. Because then if you get an objection, what do you say? What do you say to the judge? Your Honor, this isn't evidence. This is just a preview of the evidence. I mean, what's the judge going to say to that? I mean, how do you really argue with that? Your Honor, this is just a preview of the evidence. We have no idea what the evidence is going to be until it's presented. This is just a preview of it, and the defense has made that clear from the very beginning. I mean, the prosecutor, they can't object to a whole lot at that point because they don't know what the evidence is going to be, other than their case in chief. So, ladies and gentlemen of the jury, the evidence will show. And then you walk through what evidence you intend to present. Now, obviously, you want to weave in there your case, your arguments, your theories of the case, et cetera, et cetera. I'm not saying it needs to be sterile, but you want to make sure you protect yourself with, ladies and gentlemen of the jury, the evidence will show. So, okay, so let's backtrack. May it please the court. Okay, look at the judge, nod, bow, curtsy, whatever you want to do, all right? So, may it please the court, counsel, and ladies and gentlemen of the jury. And then take a step forward, take a big deep breath, pray, and you say, ladies and gentlemen of the jury, the evidence will show, and then walk right into your case. Okay? That's an opening. That's an opening. That's all it is. That is all it is right there. You've got the decorum aspect of it down. You've got the preview, okay? And then make sure throughout your opening, you remind the jury, the evidence will show that on this particular date, at this particular time, the prosecutor may believe that this happened, but this is what the evidence will actually show, okay? Don't be afraid to recite that portion. The evidence will show, all right, because you are once again previewing. Okay, practice tip. Address the use of opening exhibits before the trial begins. Diagrams, charts, and pictures are acceptable, but work this out between you or between yourself and opposing counsel before the trial. Don't have a big knockdown drag out about those aspects. Address those, file a motion. Usually you can just talk it out in chambers, or you can just say to the prosecutor, hey, are you going to object? I've got a map or I've got a diagram. And if you have a good rapport with the prosecutor, I'm just going to be honest, they're going to say, no, it's just fine, whatever. So there's not going to be a whole lot of fighting over something like that. But just make sure you know that you can use charts, diagrams, pictures. Remember, they're not in evidence. They haven't been offered and admitted into evidence, but you can use those. Just make sure you address that with the court and with opposing counsel before. Okay. All right, don't presume the prosecutor knows the appropriate boundaries during opening. I can tell you that when I was a prosecutor, I didn't know. I didn't know what I was doing at all. And I sure didn't know the appropriate boundaries. And a lot of prosecutors, they either don't know, or occasionally you're going to find some that try to push the envelope. I think prosecutors as a whole are great in terms of working relationships go. I mean, it wasn't a good fit for me, but I've enjoyed working with virtually every prosecutor I've ever met. So don't presume the prosecutor knows the appropriate boundaries. Practice tip number 2, file a motion in limine to prevent the prosecutor from addressing inadmissible evidence during opening and the remaining phases of trial. This is really simple, all right? All you're going to do is find out when the judge expects those motions, those pretrial motions. Some judges are fine with you presenting that motion the day of trial, so right before you get into voir dire. But if the judge wants them taken up a month before, just make sure you know that. Motion in limine. What's the point of a motion in limine? Yeah, okay, housekeeping. What else? Okay, keep out evidence. Good, good. So why would you want to protect yourself through a motion in limine? What obvious advantage is it going to give you at the outset? Yes? You know ahead of time what's going to be admissible and inadmissible. Sure. Good, good, good. Good, good. The other thing is I think it's great to argue. I mean, if the judge is going to allow you to argue motions in limine way before the beginning of trial, I think that's great because it gives you an opportunity to kind of ferret out what the prosecutor is going to be trying to limit from your side. And if you have that month buffer, you can use that to your advantage, I think. Okay. Practice tip number 3, do not underestimate how much success a motion in limine can leverage in your favor. The momentum that comes from limiting the prosecutor's evidence cannot be fully comprehended until you actually succeed in doing this and observe the effects of your momentum thereafter. So what am I referring to? Particularly in a DWI trial, since this is about DWIs. Matt, tell me what kind of things you, in your practice, that you like to try to exclude.
Sobriety test.
Okay, sure. Sure. Field sobriety tests. Anything else? Okay. Refusals. Good. Yes.
Portable breath test.
Okay. Portable PBT. Good. What else?
Accusations of why they were pulled over.
Okay. Absolutely. Accusations of why they were pulled over. Remember, you're not going to win every single point you make. I mean, you could, I guess. That'd be great. But at least you're protecting yourself in terms of ineffective assistance of counsel arguments down the road. And you're also putting that in there and giving the judge something to think about in terms of the law behind your motion. So, I mean, if you can exclude it, the momentum that you're going to build in terms of success, it's going to carry with you throughout that trial. Okay. Limit the prosecutor's opening to that which is admissible. The purpose of a motion in limine is to point out to the court and to opposing counsel which anticipated evidence might be objectionable. Motions in limine are interlocutory, and the motion in limine does not preserve an objection for appeal. All right, so we get to this portion where the defense is not required to make an opening statement. You're not required. But why would you want to miss this opportunity? Don't miss it, all right? Capitalize on that opportunity. Don't waive it. It's reviewable under 2915, so going back to ineffective assistance of counsel. The prosecutor will open first. Listen closely because the prosecutor will develop a theme early. Your opening should counter with your theme and theory of the case. In other words, do not be afraid to use your opening as an opportunity for rebuttal, okay? So that makes sense. So what must the prosecutor do? What must the prosecutor do? Do tell. Matt? What must the prosecutor do in their opening?
Lots of things that they must do. They gotta lay all the elements of their case, or else you can dismiss.
Beautiful, beautiful, beautiful. Good, good, good. So the prosecutor needs to lay out the elements of their case. And listen, because the prosecutor will so often fail to do this. So use it as an opportunity to raise your motion early. So for a judgment of acquittal. All right, so jury instructions. We talked a little bit, I mentioned that a little bit. So why are the jury instructions important in your case in chief? Why, sir? Yep.
That's the key to the whole trial. You have to know what the elements are before you begin.
Perfect, perfect, perfect. What he said was that is the key to the whole trial. You've got to know the elements from the very jump. From the very beginning, you've got to know the elements. Where are you going to find those? In the jury instructions. So the jury instructions are going to lay out what elements the prosecutor has to tick off in order to make their case. What you're going to find is prosecutors in their closing argument, they always do this. It's the same thing. They always put a PowerPoint that has the elements listed out, and they have the check mark next to each particular element that they just walk through, and they say, ladies and gentlemen of the jury, we have proven our case through this, and this, okay? It's the same thing every single time. So, you need to, in the very beginning, when you take the case, you need to, obviously the law is important, but I'd argue that the jury instructions are infinitely more important because they're going to crystallize that law and they're going to divide it out into exact measurements of what the prosecutor has to do to meet their burden. So that is extremely important. Obviously, during the prosecutor's opening, make sure you have a copy of the jury instructions, particularly the verdict directors, that you can just walk through and say to yourself, is the prosecutor making a case in opening that's satisfactory? So that is probably one of the biggest mistakes I made as a prosecutor, is I never took that advice to heart. I never grabbed the jury instructions early. I just kind of went with my gut and emotion and all these other things and said, oh, this person's guilty of something. And so, boom, busted off a charge, and away we went. So those jury instructions, if I really would have had the ability to go back and do that job over again, I would have had the jury instructions even during charging. I would have, there's a lot of things I wish I would have done over again or done differently, but that's certainly one of them. So, okay. So the prosecutor cannot, and these are opportunities for objection. If you feel as though the prosecutor has overstepped too much, then obviously you can argue for a mistrial. Strategically, everybody's got to weigh that, but at least you want at the minimum make an objection to preserve it for appeal. Refer to the defendant's post-arrest silence or failure to talk to the police. That's pretty simple. Refer to the victim's identification of the defendant at a preliminary hearing. This is one I just learned in getting ready for this particular class. So refer to other crimes committed by the defendant. Read an affidavit made by a witness in a preliminary proceeding. Once again, I have never seen this happen, never heard of it happening, never thought of it, but that makes perfect sense. Express an opinion as to the guilt of the defendant. You will see prosecutors do this all day long, okay? They are going to express opinions as to the guilt of the defendant. Why is this objectionable? This is very nuanced. Yes, sir.
Their personal opinion doesn't matter.
Okay. Whose opinion does it matter? Yes.
They almost become a witness in that regard. It's
Okay.
like they're testifying against the defendant.
Okay. And they're invading the prominence of
The jury.
the jury. Okay. They're invading the fact finder's essentially role in this process. So, so express an opinion as the guilt of the defendant. Make sure you object on that one because you're going to see it early and often. Yes.
So, apart from just an objection based on it, what's kind of like our remedy? Is there a motion for an acquittal there, or
Well,
that probably wouldn't be successful? Or?
you know, the reality is what I always do in this particular case, I don't ask for a mistrial. I don't ask for anything extreme, but you want to at least make sure there's some type of limiting instruction that the judge provides. The problem with the limiting instruction is, of course, when the judge does provide that to the jury's like, ooh, this must be important, you know, so that normally they would have just potentially not even heard it, but now that you've drawn attention to it, sometimes they really fix on it, so you didn't really accomplish what you wanted in the first place. But the reality is I think some of it is just creating good prosecutors through your objection, and in some ways training the prosecutor. Once they realize that, okay, this is something that the judge is going to sustain your objection on, they're not going to bring that up again. I mean, so it's the other thing is momentum. I think one of the greatest things you can do for your client is when you feel there's momentum building behind the prosecutor, throw out an objection. Who cares? I mean, it's going to cause them to kind of put a hitch in their step, and they're going to lose some of that momentum. So, I don't know. I mean, some people, I don't know what other people argue, but I don't think you're going to, in fact, I know you're not going to get a mistrial on something like that. So, okay. All right, comment on the failure to testify or state that the defendant will testify. So the prosecutor can't get up in their opening and say, well, the defendant will have you believe, or the defendant will, they can't do any of that, okay? Because obviously the defendant has the right to remain silent, so what the prosecutor believes the defendant may say or may think, it's not acceptable for the prosecutor to get into that. 10 simple rules for opening your case. Begin with the evidence will show. We talked a little bit about that. The evidence will show. Just remember that. That's the magic word or magic phrase that you have to ingrain in yourself concerning your opening. Briefly preview the evidence that will be addressed throughout the trial. Okay, preview the evidence. The opening is a preview. Build your opening around a theme. Do tell, why would you want to build your opening around a theme? Why would you want to build your opening around a theme? You know the prosecutor is going to do it.
To reframe the narrative
Okay.
for the jury.
Sure. Good. Say that a little bit louder.
To reframe the narrative for the jury.
Good. Reframe the narrative. Excellent. Other reasons? Yes.
It's something you can go back to throughout the course of your case.
Okay. Something you can go back to. Excellent. Excellent. Other reasons?
Juries like storytelling.
Yeah, just more memorable. Absolutely. Absolutely. Okay, don't state as fact something about which there will be no evidence. I'm reading currently Christopher Darden's book on the O.J. Simpson trial. Obviously, he was one of the prosecutors. His book is In Contempt, great book. I didn't realize that during that trial, the defense, during their opening, had promised so many witnesses that they did not actually put forward. What's the danger in that type of miscalculation? Okay, makes your case look weak when you don't follow through.
It makes the jury speculate and run wild. You don't know what they're going to think.
Sure, sure. You don't. Yeah, it makes them speculate. What else? Yes.
Makes the jury lose trust in you.
Beautiful, beautiful. credibility and trust are hand in hand. That's essentially what you have to ask yourself is when you're developing credibility, at the heart of that term is the concept of trust. So through OJ's defense team, when they promised that the jury would hear testimony from X, Y, Z, A, B, and C, and then they never presented those witnesses in their case in chief, one of the things that they were obviously risking is their own credibility, all right? And so when I've been reading a ton of books about the OJ trial just because I didn't know a whole lot, and some of those aspects of the trial I'm just now finding out. Don't state as fact something about which there will be no evidence. So you don't want to compromise that trust that you have that you've built thus far with the jury, okay? Don't personalize. This is something that I catch objections to like there's no tomorrow. Don't personalize. What do we mean by don't personalize? What do we mean? What would be one way a prosecutor or defense attorney might personalize an opening or a closing? You don't see it in direct or cross as much anyway. In fact, I don't think I've ever heard that objection in direct or cross. But you see it in opening, you see it in closing. Yes, yes ma'am. Yes.
You say a story about yourself? You put yourself in it?
Absolutely. She said, you tell a story about yourself. Classic personalization. Yes?
Maybe not so much as personalization, but I could see them maybe painting a broader picture on how drunk driving affects society in general and the dangers that it poses to, everyday people.
Absolutely. Absolutely.
Is that what's called a golden rule violation, or is that something else?
I think what you're referring to is when you're asking the jury to put themselves in the shoes of someone else.
Oh.
I think that's what you're referring to. But yeah, personalization's a big one. So the case isn't about me, the defense attorney, all right? The case isn't about the prosecutor. The case is about what? The evidence. It's always, I had a boss, he's one of the prosecutors in Clay County now, Rob Sanders, best boss I've ever had. Rob would tell me, it's not about you, Greg. It's just not about you. It's about the evidence. And he was so on point. And when he finally said that, it's like a light bulb went off. And ever since then, that's probably one of the best pieces of advice anybody's ever given me. It's about the evidence or lack thereof. It's not about you. It's not about the prosecutor. It's about the evidence. Okay? So, don't personalize. Address the humanity of the case. Address the humanity. Kevin Regan is the defense attorney for the Chiefs. Gets called in whenever one of the Chiefs get in trouble. Great guy. Great guy. Kevin, I watched him in trial one time, and he said something that absolutely I stole from him and continue to use. He says at the end of every trial, he says, ladies and gentlemen of the jury, let's talk about the humanity of this case. Okay? What does he mean by that? The evidence is important, but Kevin's able to step into a different realm when he says, let's talk about the humanity of the case. And then he'll argue the humanity of the case. Different from personalization, but very, very close. What does he mean? He just brings it to a level that is just a basic fundamental, you're a person, I'm a person, let's just cut right to the chase and talk about what this case is about. Man to man, woman to woman, man to woman. Forget race, color, creed, ethnicity, sexual orientation. Let's just cut right to the chase and talk about the humanity of the case. And Kevin's able to do that, and I will tell you, you will see judges and juries lean forward all the time. all the time. They lean forward because all of a sudden, Kevin's no longer a lawyer. He's a person speaking to other people. And it is so powerful, so powerful. So don't forget about the humanity of the case. The evidence is important. You've discussed that, but make sure you don't forget about the humanity of the case.
Just for example.
Yes.
What would he, because I'm not connecting thoroughly on it.
So I saw him do it on a self-defense case. So on a self-defense case, basically what he argued was, on a very basic level, a right that transcends race, color, creed, sexual orientation is the right to self-defense. It transcends the law, it transcends all of us, and it's a basic fundamental right. So he was able to crystallize self-defense in a way that it didn't need a law degree to, you didn't need a law degree to really capture that. And all of a sudden you see jurors really lean forward, you see some of this, and you just see the room it takes a different posture. And all of a sudden, I said to myself, oh, Kevin's got this one. I mean, it's just, he was able to talk about the evidence that was in favor of the client, and then he was able to dovetail it with the very human aspect of one's right to self-defense. So, really powerful. Okay. If you have a weakness in the case, address it early. All right? What do we call this? Draw the sting. All right? Draw the sting. You know you're going to get stung, get it out of the way early. Get it out of the way in your opening. Enjoy yourself. You're a trial lawyer. All right? There's no better feeling than trying a case. I know it hurts to lose. Man, I know that. But you're trying a case, you're up there, your client sees you prepared, your client sees you enthusiastic, your client sees you actively fighting for him or her. No better feeling. No better feeling. And it's something that I will tell you every single day. I thank God for the privilege of being able to try a case every single day. Even if you don't try very many of them, great, great, great feeling. And try them early and often. Okay. Ask the jury to listen to all the evidence and instructions on the law before deciding the case. Makes sense. Tell the jury you will be asking them for an acquittal during your closing argument. Set them up and then deliver at closing. You're setting them up in the beginning and telling them what you're going to be asking during your closing argument. You're going to be asking for an acquittal. And then in your closing argument, you've already primed the pump. All right? You let them know in your opening that you are going to be asking for an acquittal. So at the very end, you look at them, don't blink, don't flinch, say to them in the most straightforward and humble way you know how, ladies and gentlemen of the jury, I am asking you to walk my client out of this room innocent of the charges that he or she has been charged with. Do not flinch. Say it strong, say it proudly. And you know what? The jury will know where your heart is, and oftentimes they will walk that person out. Okay, so this list, I quoted a couple of those I took from the Trial Master's book. What questions? Thank you, guys. If there's any questions, please holler at me. I will tell you, if you're young and you're just getting started and you need assistance, please call me. If you need any type of resources, books, whatever, I will share early and often with you. Thank you for your commitment to the law. This is a great, great profession, and I'm honored to be part of it. Thanks, folks.